The Law Show on CL 650. A comprehensive look at everything you need to know about the law.
It's a legal matter, baby. A legal matter from now on.
And welcome to the show. I'm Zach Spencer, and today we're going to be talking about something that is very important to your life and then what happens after you pass, especially when it comes to children. We're talking about wills and estates, and we have in studio today Alyssa Lockhart, a partner at McQuarrie Hunter, and Leah Donaldson, also from McQuarrie Hunter. So I'm going to start off generally by just asking the big question, what do estate lawyers do? What is it that you do from the 30,000-foot level? How can you describe it?
Well, from that 30,000-foot level, we help people to plan the transition of their assets from one generation to another. Mm-hmm. And on Leah's side,
I deal if there's conflict or there's questions to be asked about the planning documents or the lack thereof, try to help clients resolve those conflicts.
And are you busier? Is the conflict side increasing? I
think the conflict side is increasing, but so is the planning side. I think people recognize the importance of it. But yeah, I've definitely noticed an increase in the conflict side of things. And that hopefully is still resolved by negotiation, but if necessary, we're ready to go to court and litigate it if it's required. And
it's a big part of this is obviously money, right? It comes down to money at the end of the day. What do people fight over more? Is it the money or the things? Like mom's watch or ring or something like that?
Well, I have seen a family come to almost physical blows over dad's Timex watch.
Really?
Nothing can be said more strongly than the fact that there's got to be a process that mom and dad set out for the transition of their assets, whether they're of significant financial value or simply purely emotional value. Because we all have that relative where we'll be in the back seat driving to the home for the first viewing and itemizing the assets after the passing of someone, and they'll say from the back seat, that hutch in the corner of the kitchen would really look nice in my oldest daughter's brand new apartment, mm-hmm. or my son just had a new baby, so really needs a new bedroom set, and all of those sorts of things. I call it the shotgun kid. They always call shotgun on everything, mm-hmm. and that puts other family members at a disadvantage because by the time they get there, they feel like all of these things have already been itemized by someone else. They don't want to speak up and upset the family. So we always talk about what's the process that mom and dad would want. Should everybody take turns? Tallest to shortest, oldest to youngest? Are there specific assets as a parent that I think, well, that was really special for me when I bought it with this one child, mm-hmm. and I want it to go? So do we itemize or do we just set up a process? But leaving people to guess or leaving people to be assertive or take a back seat, that's really what causes a lot of the stress over those personal assets.
So do you list item by item things that you want to go to individual? I mean, I guess there's heirlooms that those would be the ones that are fought over.
To a certain extent, or we might say my collection of. We frequently, I'll hear clients all the time say, don't worry about that, I'm going to give it away before I die. I'm very interested to talk to those clients about how they know when they're going to die, because I don't know when I'm going to go. But yeah, there are different ways we can do that. I like the process being set up. Sometimes I'll say to clients, from my own background, I have a lot of Hungarian cousins. When I was 15, just about 16, my grandfather died, and he had a beautiful car. And I was the first grandchild to pick an item. And I think all the boys assumed I would pick that beautiful car, and they were probably gnashing their teeth behind me. But I selected a small figurine of a buffalo that sat on his windowsill for maybe 40, 45 years mm-hmm. throughout his marriage to my grandmother. It's white on one side where the sun faded it, and it's a buffalo on the other side. And I attached that buffalo to all of my memories of my grandparents. Mm-hmm. I didn't want to let it go into the next phase of selection, having so many cousins, because what if it wasn't there when I got back to my second choice? Mm-hmm. So by setting up a process, parents are really allowing children to self-select what they place value on. Mm-hmm. Some people will take the car and then sell it on Craigslist the very next day. because
take the
they
money.
place value on the money.
Right.
Other people will choose the ceramic
sentimental.
buffalo.
Right. That's a great story.
I have clients who bring me buffaloes because they think I love buffaloes.
That's interesting. All right. So when you have a situation where you have the disparity between siblings going into the house, and I want the buffalo, and so does the other child, and it hasn't been set out in a process, can that get to court over those simple things?
It can, unfortunately. I haven't been to court on an item yet, but we do see that as something that people need estate litigators to help them negotiate and walk them through and hopefully resolve. But the reality is that there's a lot of sentimental value placed on sometimes items that have no monetary value, and it's very expensive to negotiate or litigate something like that. So having a process set out just takes that sort of guesswork away, and then you know that won't happen to your family members.
Pets. What happens with pets?
Well, it really depends. Sometimes we know that the pet will attach to another family member. Other times the family members are not in a position to take, so we'll ask around, we'll ask our friends and family. I personally am the trustee for 2 horses. A client of mine who was also a friend. I don't step in and act as trustee lightly. It's not something professionally that lawyers frequently do. But I act as trustee for horses, and money was left for their care and maintenance after my friend died. She became ill and was diagnosed at a young age, and she wanted a certain care provided for the animals so we can take care of them afterwards, which is a very interesting type of trust.
It is. And some animals, especially horses, are expensive. So you want that clearly.
They can live a long time.
They can. So you need to have that clearly set out what money can be used for their care.
And then you would have siblings saying, well, that's ridiculous that we're spending all of this money on a horse. Let's sell the horse.
Well, we don't typically advise that people leave significant assets to their animals. Obviously, if there are children, particularly young children, those are the driving factors that our clients come to us being worried about, is the care of their loved ones. And if they include their pets as their primary loved ones, then yes, it can be a factor. But we wouldn't generally see a horse being placed above offspring.
Okay, so let's get into children. So if you don't have a will, or you have a simple will, and you have minor children, what are the complications?
Well, the simple will frightens me the most, because people will assume that either they're in a nuclear family or they're in a blended family with a spouse that they feel is committed to their children, and therefore we just want to pass the assets between husband and wife, and then after the death of the last of us, then we'll flow the assets down to our children. It's very difficult when you have what we typically in the legal industry call a simple will, which can either be from a notary. Notaries are great at drafting the simple wills back to back between husband and wife. It's one of the primary services they provide. Or from the Self-Counsel Press Wills Kit. It's a very simple document that a person can feel that they've answered all of the questions, and therefore they have this will that's suitable. Or sometimes from the internet. And the challenge with the internet is we're downloading things that might be from Alabama or Albania, but not from BC. So we don't know the jurisdiction of origin on those documents. That's where simple wills typically come from. When we look at minor children, a simple will typically doesn't have trust clauses drafted into it. And what a trust clause will do for a minor child is it will say, rather than the funds flowing to the child immediately at the age of 19, let's say we live in the GVRD, we have property, that alone can cause our estate to exceed well over $1 million at this point. If we have RRSPs, work life insurance, private life insurance, any savings whatsoever. So would I want my 19-year-old receiving $1.75 million? Absolutely not. Do I want my child protected in my absence from the misconceptions of youth that $1 million or $2 million can last forever. So those are the challenges with a simple will, is that we don't have the ability to necessarily craft a proper trust clause that says 10% at age 19, just to see what they can do with it and see how quickly it can be spent or perhaps wasted. And then 20% at the age of 25, the residue at 30 or the residue at 40. We don't have a trustee set up who will take care of the child during the interim, where all of the money is accessible to a trustee for viable purposes, education, buying a first home. If you have a good business plan, it doesn't matter how old you are, maybe you're ready to have money put into your business. I always like to ask clients if they think their young adult children are fully cooked or not. Is this one fully cooked? Sometimes they are. Sometimes the client
Very
says,
responsible.
this one has it going on. This one brought me a business plan, asked for a loan with interest, and I'm good. Others will say, oh, this one's 35 and not yet fully cooked. Other clients they'll have the simple will and it won't have trust clauses drafted into it. And then they'll come to me and they'll say, well, we really are concerned about this because one of our children is with a person that we don't think will be permanent in their life. So what we want to make sure is that the asset doesn't flow into their hands during the relationship.
I'll tell you what we're going to do. We'll take a quick break there and we'll pick that up because I want to find out more about that and how long you can spread out this trust. Is it indefinitely? We're going to find out more about that. Joining us in studio is Alyssa Lockhart, partner of McQuarrie Hunter, and Leah Donaldson, associate of McQuarrie Hunter, talking about wills and estates, and we'll pick up the conversation next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.